drug costs, Mr. Peshin, are a central question that never got, I mean, we had two different senators sort of try to ask the question, but in the exchanges with Senator Blumenthal, it was all about medical diagnostics, not about the cost of pharmaceuticals. And Dr. Leonard, when my colleague from Missouri sort of launched, you said, this is off the topic. My core assertion would be that in terms of the patentability or patent eligibility of drugs, of pharmaceuticals, PARA has almost no impact. It is very rare for pharmaceuticals to be invalidated. There is a separate issue, which is patent thicketing, patent hopping. Senator Hawley co-leads the relevant bill with Senator Klobuchar. I support it. But these are, am I correct that these are unrelated? What we're trying to do here in eligibility reform and legislation that would address abuses of the patent system to raise patent prices. Ms. Peshin, briefly. And then I have one last question.
Yes, very much so. It has a disproportionate impact on diagnostics, and you're correct.
Okay. And there was a lot of smeariness on this topic because medical diagnostics, in which you are an expert, and pharmaceuticals are basically quite different. And a lot of the senators who were here briefly failed to grasp that point. I'll just reinforce what my friend and colleague, Senator Tillis, said. Doctor, if you've got a different way for us to get at purified, there are slight differences in human genome versus any genome, and we were trying for the best language. And so if all four of you would look at that particular piece, I think what we're doing in PARA is codifying the Mayo decision that you cannot patent a human gene. But I asked you earlier about a medical research exception. We are out of time, and there's a vote we have to get to on the floor. I am wide open to, and I believe my friend and colleague is as well, refinement of this language, but this has taken an exhaustingly long time to get to, and this Congress is just about over. Director Iancu, my last question to you. We spent no time on national security. This was all about drug prices, which really wasn't that relevant to the topic. I'm really worried as the senior Democrat on defense and intelligence appropriations that we're falling behind on AI, on blockchain, on 5G. How would PARA shore up our global competitiveness in critical national security research?
I share your concerns, Senator. PARA, first of all, would bring back into the realm of patentability areas of technology such as information processing in very complicated technological ways that the courts are currently excluding. That's just one example. Same for diagnostics, where we as a nation depend a lot on China and other foreign countries. From a national national security perspective, we have to do everything we can to maximize the innovative potential of the United States. And in a free market society where inventors and investors have the free will to invest as they will or not invest at all or invest in other countries, the only way that we know how to do that at scale is what the founders recognized. It is with a reliable intellectual property system. And PARA goes a long way in that direction. There are, for sure, other things that need to be improved in the patent system. But PARA is at the threshold, Section 101, the first thing that gets analyzed, and that is something that has to be codified by the rule of law.
Senator Coons, I think it's Senator Dr. Leonard, if you'd like to speak, I think it would be fitting to have Mr. Lee have the last word.
Mine is a quick clarification.
We've got to vote.
You want language that will codify myriad.
Yes. Did I say Mayo? Yes, sorry.
No. Well, we would like it Mayo, myriad, and Alice.
If we can get back, we'll get to the office, but we are not trying to get around any of this. I think that's precisely what we're attempting to do, at least those of us who've worked on it.
In terms of the possibility of patenting human genes, we want to make sure we're not harming your work. Let me put it that narrowly.
Exactly. Mr.
And appropriately.
Lee?
Okay.
Just to answer Senator Coons, your pressing question directly. Currently, more than half of U.S. patents, I think it's 56% or something like that, and more every year, are being granted to foreign recipients and not U.S. recipients. So if you relax the rules and limits on patents across the board here in the United States, The benefit of that, some of that goes to U.S. companies, it's true. But more than half of the patents are being granted to foreign companies. So you're granting control over those technologies, more than half of them, to foreign countries or companies from foreign countries. So that should be factored in as well.
Is your argument that we should weaken the American patent system so that exclusively they can patent them overseas?
No, what I'm saying is that relaxing Section 101 limits, relaxing patent eligibility limits, and expecting that that is going to boost U.S. national security, I think it's a tenuous relationship between those, because the benefits of the patent system currently, unfortunately, and we should do something about this, are flowing more to foreign patent recipients than to U.S. patent recipients.
Okay.
You all,
Not
we're,
all- yeah.
we've worked together very well since 2019. I think the debate club thing works. I wouldn't recommend every chair doing it. But the fact, again, it is to point out that we're not here to talk past each other and score a big opening statement or a killer answer to a question, folks. We're trying to solve a problem here. And I believe that the problem exists. It may not exist, and it may not feel broken to you, but there are very demonstrable examples of where we're losing the opportunity to innovate. We just want to get that right. That this is the discourse here was great. I like the perspectives of both sides. I would encourage you all to continue to engage, and hopefully we reach a point to where everybody thinks that we got to a good work product. But this is going to conclude our hearing today. Mr. Lee, I would appreciate, for the record, if you would respond to Senator Hawley's question. And I'll take a look at it as well. The record remain open for 1 week for anyone to submit additional materials. I should also say that I'll be submitting my written opening statement for the record as well without objection. Thank you all. This hearing's adjourned.
Thank you.